assessment before the plea is taken. Mr. Mungu for defense objects to the execution of the application, and since the accused has been in police custody for close to 16 or so days, he also seeks to apply for bail or board orally. He complains that there is no evidence furnished to the court or to the defense by the prosecution. I have to note that this court is on temporary duty to give directions on urgent matters, as the judge who was supposed to be on duty is away. Therefore, does not wish to deal with the issue of board or bail. Thus, we will defer the same and any other objections which defense may wish to raise. The matter will be mentioned before the judge of the division next week on a date to be agreed. Meanwhile, the accused will be remanded in UK prison in the industrial area. The mental assessment will be undertaken, and meanwhile, it should be produced the date to be agreed. That's the last. That's how section 1 is going to be high.
One investigator called Inspector Mondi. I'd like that to go on record.
Yes. Is she terrorized because she's guilty?
I will tell you.
What is it?
Well, actually, it borders on sexual harassment.
No, Your Lordship, no, that one I'm going to strongly object, and I will.
When you invited it, I was not going to talk about it.
Your Lordship. Yes, let's raise it on Monday. He's been a former DPP. We don't expect this from him.
I have not complained about Otieno. I have complained about one.
Your Lordship, no.
And he tells her, leave your lawyers alone. He'll fix everything for her.
No.
And that is where this investigation
Your Lordship,
is going.
can we stop? Can the court give us directions?
No.
He's been a former DPP. I don't expect this from him. This is the lowest bit he could ever have gone.
My Lord, please indicate that, because I intend to take it up with the DCI. Yes, thank you.
Let's have the matter on Monday.
In fact, Your Lordship, I don't even know why he's going that. He knows for us we will not object. If they want to bring as many doctors.
Nothing processed. I have the pictures of the visit to our home yesterday. All because we have visitors from Holland. I think they should have taken their time.
Can the court just, as much as he has the right to speak, we need to respect all parties here. He needs to respect even the Office of the Director of Public Prosecutions. Our work is not to act under any influence, duress, or interference. I have said we made a decision, and not because we have visitors here. And we need to respect the office. And Your Lordship, and that is why I'm urging this court to just make its direction. Even if the court will tell us to bring one statement tomorrow to affix to this, we will. Or, Your Lordship, because, and my learned friend needs to be very clear, the procedure here is that once someone is brought and mental assessment has not been done, it's important that mental assessment is done before plea taking. We can advance quite a number of what we have before the date for plea. And that will be sufficient for everyone, because she can't take plea today. We need her assessed. We don't know whether the results will come. She's not mentally fit for her to be remanded wherever, or for her to go for treatment. If she's mentally fit, Your Lordship, by then we will have given the court and the defense what we have. Even I can guarantee the court it's not all, because investigations are ongoing. We all know the government chemist will take some time, but we, on our own, we made that decision based on what we have. And they do not know what we have. They do not know the witnesses that we have. And Your Lordship, another thing we also tread carefully as an office, there are some witnesses in the course of this whole process who may need protection. And we need to secure even their statements and keep them aside based on the information that we will get. So even before we give them the whole bundle, we must have selected who is to be put under protection and who is not to be put, so that we don't jeopardize their identity. So those are things that we look into. We look into so many things, or we take into consideration so many things before we hand over, because our paramount work is to ensure that all witnesses are protected and the evidence is protected. So I'm urging this court to allow her to go for mental assessment, and by the time the plea is taken, Your Lordship, we will have given you what we believe can be given out, and what cannot be given out, we will contact the relevant agency, that's the Witness Protection Agency, to be able to do what they have to do without your interference, and they will give us a feedback. That is just my prayer.
I'm just trying to conclude my submission. She has now said the investigations are still ongoing. That is an important concession. The issue here, the reason why my learned friend, let me also respond to the fact that she did tell me that the statements are not ready and they will be provided on Friday, and I've seen the exchange between her and the investigating officer. The investigating officer says next Friday, not tomorrow. So I'm already going to what she's trying to preempt. Of course we'll be applying for bail. We are entitled to bail. 16 days later, their house should have been sorted out. So if they want a mention tomorrow to give us some evidence to support the charge, in order to then found an application for a mental examination, they're entitled to. But I think we would be objecting to any plea being taken, and we, in this forum today, want to make a formal application, oral application for bail. The issue of the foreigners is not new. She is new to the matter. For some of us, this is what our file looks like. We've been fighting this matter for the last 16 days. This is the first volume. The issue of foreigners featured from the mouth of Assistant Deputy Director of Public Prosecutions, Muteti, who is on record as stating that this case is affecting bilateral relations between the Kenya government and the Dutch government. So it's not something she can take away. We're hopping up and down because of the bilateral relations. And we challenge them to charge her if there's evidence. They now have attempted to do so. Clearly there's a problem with the charge. She has been in custody for 16 days. I can give a catalogue. I have a catalogue of what she did on those days. Absolutely nothing in her cell in Muthaiga, except visit her home. And only yesterday and the day before, rushed to go and take her around the house. The director of CID around the house where the bathroom, the kitchen, and the toilet was, and the bedroom of Tob Cohen was. But time has finally run out on them. The question of witnesses, witness protection, featured 12 days ago when Mr. Otieno, the investigating officer, took the stand. He was told, if you have vulnerable witnesses, place them under the witness protection program. He said that is entirely his business. I hope he has done it, if he has any such witness. For now, my Lord, it's not a question of mental examination, it's a question of custody that we are concerned with. She has been brought here. The time for holding her in custody expires at midnight. The matter that we would like to be attended to. She now has said she doesn't want the plea taken, she wants mental examination. We wish to formally apply for, not formally, orally apply for bail for Sarah Wayunicorn, since she's not an accused yet. And we're ready to proceed.
Just briefly, Your Lordship, she's not a special case. All the procedure here is that once a person is brought before the court and mental assessment has not been conducted, mental assessment has to be conducted first. The person is supposed to be remanded in custody and then plea taken. After plea is taken, then we canvass the issues of bail. She should not be treated or accorded any special privilege or anything. She needs to be treated like any other person, just like the young boy who was here before. I therefore urge this court do what is done to everyone else who is arraigned before this court to allow us to take plea, mental assessment plea, then we can canvass the issues of bail, and not at this junction. That is it.
Absolutely. My sister could tell us which is the procedure that requires the mental assessment and at what stage.
Your Lordship, it is the procedure in all murder cases. It happens here and everywhere else because it is important for us to assess the person's mind.
That document is copies of the evidence which the prosecution intends to adduce at your trial are attached herewith, full stop. Meaning, this document is not worth the paper it is written on unless it has the evidence which the prosecution intends to adduce at the trial. And it should be, that bundle should be with us here and now. I have inquired at the registry. They have not been able to explain to me why they have broken their own rules. They referred me to a DR called Stella, who is not in her office. So, before there can be an application to refer anyone for mental assessment, let alone the lady sitting there, because she's not yet an accused, the document must be complete. There must be evidence. I say this not lightly. We take the position that there is not a shred of evidence against this lady. That is why it hasn't been produced today. She is being paraded here to please some foreign visitors, that's all.
Your Lordship, with all respect and due respect to my senior learned friend, the information is what has been presented in court and is what is read to the accused. We have informed him and the registry that we will be supplying the statements by Friday. That is part of the statements, because the prosecution has the leeway until the close of the prosecution's case to advance its evidence. Plea cannot be taken today, as mental assessment has not even been conducted. And we undertake, as we promised the registry, to advance our statements, the ones we have, because they even have to be typed as per the procedure in the Milimani law courts. What is provided are typed statements. And I did indicate that we are in the process of typing the statements, and we will give them in good time. In the meantime, Your Honor, Your Lordship, I do pray that we do advance and by proceeding to have her mental assessment taken, and we will supply the same before the plea is taken. That we reassure the defense and we reassure the court that we will have supplied what we have, noting that we are not bound by that. We have until the close of the prosecution in case any new evidence is advanced. So we pray that we will be allowed to proceed, and as I said, we reassure the court. Your Lordship, in terms of whether there is a body or not, that is evidence that we will tender. The law is very clear. We can proceed without even a dead body. An accused can be convicted without even a dead body, and that is what we'll be advancing in the course of the trial. My senior learned friend has to hold on and wait and see what evidence we will advance or supply to him before he even comments on whether the information as it stated, whether there is a deceased body or not, whether it can stand or not. And he has the leeway at the close of the prosecution's case to make such submissions. We pray Your Lordship to allow us to proceed with this matter.
My short reply. If there was some evidence, I would be happy to concede that she is allowed to bring further evidence, because that is normal, we know that. There is not a shred of evidence, not a shred, not an iota, absolutely nothing. So much so that I'm inclined to ask the court to look at the constitutional provision, the right to a fair hearing, Article 50, 152J, which provides that an accused person has the right to be informed in advance. In advance. My Lord, for those of us who were prosecuting many, many years ago, we know why that article and this procedure was introduced. It used to be the practice for investigators, the Kenya police, to charge an individual with a simple piece of paper like this, and 5 years later they'd be acquitted. That would be the end of the matter. So the mischief was there was a lot of abuse of process.
Your Lordship,
It was
will I be allowed
amended.
to, sorry, with all due respect to my senior learned, will I be allowed to respond to that?
Yes.
Because I believe that is not a reply to one of the issues that I have raised. So if he's talking about what's the procedure, I'll be saying that we have done this in this court. This is not the first time we have registered an information without the statements.
Just finish. I have no right. I have no problem with her replying to anything I say. There was a young man here who had no advocate, and who will get an advocate free of charge and so on. I'm sure they can do things like that when there is no advocate present. But when there is an advocate present, the law must be followed to the letter. Yes.
Yeah, I just wanted to inform to start with the judge who was supposed to be duty to give directions to the motor which are coming under certificate of urgency. And normally,
Are you stationed in Nairobi?
sorry?
Are you stationed in Nairobi?
No,
Oh.
this one in Garissa.
Oh.
That's why I came to start for the judge to submit the so today and tomorrow. Anything urgent, I give directions.
My Lord, then you're still
So if they would make,
Yeah.
I would request to allow us to give direction. So that will appear before the judge will give the decision next week.
There's a difficulty with that.
Yeah.
The difficulty is that one of the reasons why this charge has been brought was because today at midnight, the order that was in place placing her in custody lapses at midnight today.
No. Your Lordship, I will totally object to that. We made a decision based on what we have. If we required more time, would have come for extension of time. But we based on a decision based on the evidence that we have today. So whether we were given until the end of midnight or until tomorrow, we would have made a decision. And that's not the reason why we're here. It's because we have looked at what primarily we have and we are satisfied with what we have. That caused us to recommend or direct that she be charged with the offense of murder. So it's not that because we were given until the end of midnight. And Your Lordship, I totally agree with you. We have arraigned her before this court. We seek your directions on the way forward.
He's trying to make my point, my Lord. If you will allow me, and then she can respond. That order is in place, and I was responding to you, not to her, when you said, can we place this before a judge next week? And I said there will be that issue of whether or not she should be released from custody. And I have said that could probably be one of the reasons why it prompted my friends to come to court. She mentioned a good point. They could have come for extension. Perhaps that is what they should have done. But to come with a piece of paper without a shred of evidence and expect that that will end the matter, especially when they now apply that she be sent to some place for a mental examination, is to abuse the criminal justice system. There must be enough before the court, meaning a charge supported by evidence, whether valid or not, whether admissible or not, is now not the matter. But right now, it doesn't even exist. It doesn't even exist. And my instructions are, it doesn't exist. That's why it has not been placed. Yes, mandatory practice.
There are exceptional cases, and I have been here. Maybe my senior learned friend has not been here. There are exceptional cases, and we then have to advance the exceptional mark or issues before the judge to give us And for us, we've just requested for them to have what we have be tight.